The Mountain West is going to destroy the Pac-12 in terms of the exit fee lawsuits between the departing members and the conference. I took the time to write out an actual motion to dismiss, to deeply study the Pac-12's amended complaint, and I want to break it all down for you guys. This is the Let's Run podcast. Guys, thank you so much for checking out the video today. I really do appreciate all of the support that we've gotten. In our first week back, it's been a sterling success, I would say. Please, while you are here, do like this video. This is easily the most intensely that I've ever prepared for a video. The most effort that I've put in kind of off camera in researching, analyzing, and crafting this motion to dismiss that I wrote. And, you know, this video took a lot of effort. You know, it's probably 7, 8, 9 hours of just research, reading, and writing. But I'm a junkie for this stuff. And when it comes to sports litigation, college sports litigation, I'm not an attorney yet. I have graduated from law school. I've taken the bar exam. I am awaiting results. So, you know, take everything I say with a slight grain of salt. This isn't, you know, legal advice or anything along those fronts. But I do think that I am a person that cares enough to actually read into the law and really study this. So I would really appreciate a like on this video, a subscribe to the channel, so that we can hit that 500 subscriber mark before the season starts, and really just so that we can get into this. It looks like I don't have my overlay on. That's kind of crazy. There we go. So guys, let's start out by talking about the kind of the order of events here. Let's share screen. And let's go over here. So the title of this is the Pac-12's arguments over exit fees suck. Now I can hear a lot of you typing already. I want to clarify a few things about the language that we're going to use during this video, and just a few countervailing thoughts that I want kind of overarching and really just kind of sitting over the rest of this conversation. This case is about the exit fees, not the poaching fees. The two are related, but they are two separate claims filed in two separate courts. The Pac-12 as a conference itself filed the poaching fees claim in the Northern District of California. Like I say in point number 2 here, I believe that the Pac-12's case on poaching penalties is much stronger than this one. So when I say, you know, the Pac-12's arguments over exit fees suck, that is not something that I would say about the poaching claims. They are two distinct legal claims. And so the next thing I think that's important is point number 4 here. The actual plaintiffs in this case are Utah State, Colorado State, and Boise State. Saying that the Pac-12 is the party suing over the exit fees isn't really precise. It's not exactly true. It's only these 3 schools. And additionally, San Diego State and Fresno State are not technically a part of this lawsuit, although they are basically in spirit. The outcome of this lawsuit means just as much to those 2 schools as it does to Utah State, Colorado State, and Boise State. The only reason that San Diego State and Fresno State are not a part of this lawsuit is because they're a part of they're part of the California state school system. And San Jose State, who is technically kind of an opposing party in this motion, in this case, I should say, is on the other side of the lawsuit. So they're basically, you know, the California state school system is a little bit different. All the schools are kind of joint and united in a way that maybe other schools in other states aren't. So that is so when I say that the Pac-12 is going to lose this lawsuit, or I refer to the plaintiff side, the party challenging the exit fees, as the Pac-12 or the departing 5, know that I am kind of shorthanding it. The actual plaintiffs are Utah State, Colorado State, and Boise State. If I say Pac-12, it's because I'm using shorthand language just to kind of refer to those 3 schools. Although San Diego State and Fresno State, for all intents and purposes, are kind of a party in this case as well. And so the last point that I want to make is that despite the fact that I believe the Mountain West has a very strong case here, the Mountain West and the departing members need to come to the table and negotiate a price for the exit fees in good faith for some amount less than 3 times the annual distribution. The 3 times the annual distribution is technically the amount that these schools owe the Mountain West per the bylaws. And the Mountain West should be willing to sit down at the table and collect less than that. You know, at the end of the day, regardless of who has the stronger case here, this type of litigation is not good for the student athletes. It's not good for the universities. And despite the fact that I believe the Mountain West has the winning case here, the Mountain West needs to come to the table and negotiate and settle. And, you know, in those mediation agreements, those mediation meetings that were happening earlier on in the summer, none of us were in there. So we don't know exactly how that was being handled by the parties. But ultimately, I think it's incumbent on the Mountain West to, alongside the Pac-12, really just come to the table and get this over with, because this really is quite possibly, it's not just quite possible, it's damaging. You know, it's damaging these schools, it's damaging the student athletes, it's damaging fan bases. It's having me sitting here in a suit talking about a motion to dismiss when I would love to be previewing, you know, which I still will do. I would love to be previewing the season a bit more rather than wasting time sitting here in a suit. So the parties need to settle. That's all I'm trying to say here. And both parties need to come in good faith, Mountain West and Pac-12 side included, and just figure something out here, because this is ridiculous. It's stupid and it's hurting the student athletes. So let's talk about the procedural history here. The Pac-12, Colorado State, Utah State, Boise State, those schools, Fresno State, San Diego State, they announced their decision to leave the Pac-12 back in September 2024. They, in December 2024, filed their initial complaint over these exit fees, claiming that the exit fees are not enforceable. Mediation takes place spring 2025. In May 31st, 2025 is when the plaintiffs, the Pac-12, sent their official notices of resignation and the required $5,000 in deposits, fulfilling the Mountain West bylaws. In July 2025, mediation expires without an agreement. Litigation continues. And then August 7th, 2025, the plaintiffs filed a second amended complaint, which introduced some new claims, fraud, antitrust, records inspection. This new amended complaint, which was filed just a few days ago, included a bunch of new stuff. So the Mountain West will be filing. I don't know if they've already filed it. I'm not quite sure where the Mountain West is procedurally on this case, but they will be filing a motion to dismiss under a 12B motion, which I'll get into explaining exactly what that is. So I was able to find through the law firm Olmolveni. I'm not exactly 100% sure how to pronounce that, but I was able to find the actual amended complaint that the departing schools filed. You can see the complaint was filed in a district court in Denver, Colorado. The Mountain West as a conference is incorporated as a corporation. The Mountain West isn't just like a loose collection of schools. It's actually its own distinct corporate entity, just like the Pac-12 is. And they are incorporated in the state of Colorado. And so it was proper to bring the lawsuit there, especially with Colorado State being a member of the conference and in the state of Colorado as well. And so, you know, this is the amended complaint. It lists out the plaintiffs. It lists out who's representing each plaintiff here. And, you know, the main law firm that's handling this case is this Olmolveni lawsuit law firm, Olmolveni and Myers LLP. They're a national firm. I can't say I'm the biggest fan of them, but they are professionals. They do know what they're doing. And so this is the amended complaint. It talks about, you know, the nature of what's going on here. I'll get into this a bit more later when I break down my motion to dismiss. But it breaks down kind of the statement of facts, who the parties are, what the claims are, the allegations are. It talks about specifically what the Pac-12 wants from this, you know, from this lawsuit that they brought before the court and brought before the Mountain West. It talks about the Mountain West changing its bylaws. It talks about the current members being stripped of their voting rights and distributions being withheld. It really just breaks down the whole thing, and then it gets into you know, the Mountain West adding Grand Canyon and the timeline of that. It asks for declaratory relief. Essentially, the parties are asking the court to declare that the exit fees are an unenforceable penalty. It asks for that. It asks for an allegation which would lead to like damages, like money damages, an antitrust allegation against the Mountain West here in Colorado. I'm not here in Colorado, but it goes into an allegation of fraud, which is really steep. I mean, that was a very kind of tricky thing here. Fraud is a very serious allegation in court and requires a very high standard of proof. And, you know, they basically allege that Gloria Nevarez made representations that they weren't going to add Grand Canyon, but they added them anyway. That's what they brought up. and they claim that they were made in spring 2025. Anyway, and finally they asked that they say that the Mountain West breached the bylaws, and that here's the big one, that the Mountain West breached an implied covenant of good faith and fair dealing. And so basically, here's the whole complaint here. Here's what the Pac-12 has filed against the Mountain West. So what the next step is in a case like this is the Mountain West will read this amended complaint and file a motion to dismiss. Almost always in cases like this, unless there is some other procedural issue, which I'm not going to go into like the rules of civil procedure, but unless there's some other procedural issue in terms of like jurisdiction, parties will file a motion to dismiss, and usually they're called 12B motions. There's other ways that you can do this, but I'm trying to keep this very general and digestible for you. So the Mountain West will, I'm going to share my screen here. I'm going to share the entire screen here. So the Mountain West will file this, and sorry to open up here. And the Mountain West is going to file a motion to dismiss the complaint. There is a hearing on the motion to dismiss the poaching penalties in early September, but this motion won't be heard until later than that. Again, while we tend to talk about the poaching fees and the exit fees in the same context, they are two separate claims. And so this motion to dismiss that the Mountain West will file regarding these exit fees will not be heard, I would imagine, not at least until early October, unlike the September court trial meeting that's going to happen. And so, this is on a bit of a longer timeline than the poaching fees, and it's best to keep them separate, even though they are related. So this is what I came up with for a motion to dismiss. Basically, you're going to have, a statement of the parties. I put my own name in here. I said that my address was the Thomas and Mack Center in Las Vegas, Nevada. Attorney for the defendants. If I'm sure the Mountain West is not interested in hiring in-house counsel attorneys at this moment, but if they were, I'm here, guys. Let me in. I'll come represent you, no problem. I'll come be your in-house counsel attorney. But I wrote out, the entire motion. So the motion starts with an introduction. It goes through the procedural history. Again, the actual motion that the Mountain West files will be considerably longer than this and will have more detail. It won't quite be formatted like this. But this is just to give you an idea of what the Mountain West's response to this amended complaint will be. Statement of facts, procedural history, talking about the timeline of the lawsuit. And then it gets into the argument. And, I'm going to break down the argument for you in a slideshow so you don't have to, I'm not just going to read the motion, but essentially the argument split up into a few different sections, talking about lack of standing, talking about the notice issue and whether notice was given in September 2024 or earlier than the May 31st, 2025. This is basically what it looks like. When I prepared for this video, I wrote out this motion because I wanted to make sure that I had law backing up my arguments, that I wasn't just pulling this out of a hat. I carefully researched all of this. I will say that, especially for sections like the procedural section and the statement of facts section, I did use AI to help me out a little bit to create those a bit faster. But these are all my novel arguments. I did come up with all of these arguments, and I'm sure, I say that I came up with them. I'm sure that the Mountain West has been using these same arguments for a while now. And so this is kind of what it looks like. And the stuff that I'm talking about is backed up with case law, and I will post this motion to dismiss I'll post a link to it in the description of this video. I'll post it on Twitter so that you can read it yourself. But there's a lot of case law backing up the Mountain West position here. Specifically, I think that, there's a really good case. This Western Athletic Conference versus University of Incarnate Word was a brutal case for the Pac-12. There's several really tough cases for the Pac-12. And ultimately, I think it's important, if you're going to make arguments like this, that you actually be able to articulate, this is a legal battle. And as a guy that played high school sports and was never quite a great athlete, although I did try my absolute best, this is my field, man. Like, I'm not an expert in this field, obviously. I've gotten through law school, but I've never practiced as a sports attorney before. But this is like my passion, and so writing this out, I really helped feel like it prepared me to make this presentation for you. And so I invite you to read it yourself. I invite you to double check my citations, my references, the case law that I used, and let me know what you think. But we're not gonna read this for the presentation. We're gonna go and we're going to dive into what I always do, which is a PowerPoint. So we're gonna open this up. I think PowerPoints are a little easier to digest than the whole motion. So let's go back to the PowerPoint. So this is kind of a summary of the amended complaint. I kind of already went over this with you, but the PAC 12 is bringing up exit fee claims, antitrust claims, fraud claims, and issues that they believe that their rights of governance in the Mountain West were violated. So what is a 12B6 motion to dismiss? What I just showed you is essentially a 12B, and it doesn't have to be a 6. There are different types of 12B motions to dismiss, but this is getting a little bit technical, but stay with me here. So a motion 12B is essentially a motion to dismiss that's brought at the very beginning of a lawsuit. It is brought before discovery, before trial, obviously, before a judgment is given. And it's meant to kind of get rid of frivolous lawsuits, to kind of nip them in the bud, unnecessary lawsuits. It's kind of, think of it as a filter to get rid of the lawsuits that really just don't have a chance. And so that is what I wrote, a 12B6 motion to dismiss. That's part of it. So a motion to dismiss asks the court to dismiss a case because the complaint does not state enough facts to support a legal claim. Basically, you're saying, hey, reading this, there's just not enough here to even we don't need to go to discovery. And discovery is the process where the each side of the legal battle, exchanges documents. Essentially, they're saying we don't need to go there because looking at what they're alleging, there's not enough here that there's even any reason to go to discovery. There's not enough here for there's any reason to go to trial. The court's going to look for a no plausible legal claim. They just haven't shown a case that can be proven through discovery. They're going to look for no supporting facts. And essentially the court is going to throw out a case before a trial because there's no legal harm or valid claim. Fraud claims specifically have a heightened legal standard. Normally it's the Twombly Ashcroft-Iqbal standard, which basically means that you just have to show in your complaint a plausible claim. But for things like fraud, it has to be a little more than plausible. It has to be kind of likely. You have to make specific facts about alleged fraud, not just general accusations. And courts have held that this is a pretty high standard. So for the motion to dismiss, the Mountain West Conference argues that the plaintiffs, did not follow the official exit process and that their claims should be dismissed for not meeting legal standards. The Mountain West argument includes that the allegations of fraud, antitrust, and the claims against bylaws, against the enforcement of the bylaws, are just legally insufficient. So here we're going to discuss why the departing members' actions violated the agreed upon rules for resigning from the conference, why they did not follow the rules, and therefore they did not deserve the protection. How the exit fee and voting rights were correctly applied and in line with the bylaws as they were written, and essentially why the claims made by the universities should be dismissed by the court. The first thing that we're going to say is that the departing members lack standing. This is kind of the general gist of the entire argument. Standing in legal terms, in layman's terms, basically means if you go before a court, you have to show the court that you have suffered an actual harm, not some vague harm, not some possible future harm, but that you, by the actions of the other party, have suffered a harm. And an unjust harm, like it's not just an inconvenience, it's this party did something wrong and I suffered because of it. That's a higher standard than you might think. Then you also have to show that the court that you're in front of has the actual power to fix that harm done by the parties. So in this case, as I will show, the departing members have not suffered a harm. And yes, the court probably could fix it because the court does have jurisdiction over these parties, but there's no harm here. There's no harm here. Boise State, Utah State, Colorado State, they haven't suffered a harm. That's essentially, and I'll explain that more in depth right now, that's essentially the crux of the legal argument in this motion to dismiss. The first point is that the schools themselves failed to give proper notice under the bylaws. Now, there's a lot here. This is probably the biggest single point of this argument. So I'm going to try and be clear here. Please in the comments let me know if you think that I'm not being clear. or if you think I'm being disingenuous with any aspect of this conversation, because this is probably the most in debate part of the motion. And it's the most important probable part of the amended complaint by the departing members. The Mountain West Conference bylaws set a clear and simple resignation process that's not overly burdensome, that essentially indicates that a school has left or has ceded their rights inside the conference. It's really cheap. It's $5,000, and it's a letter to the conference. Once you have sent that in, that is what triggers your official dissolution from the conference. That is what the bylaws state. They also state that the parties have a responsibility, once they are no longer part of the conference, once they're no longer acting in the interests of the conference, to submit that. It's not just they can submit it whenever they want. They have a duty to submit it once they are acting outside of the scope of conference membership. That's also very important. By withholding the required formal resignation steps from September 2024 to May 31st, 2025, these schools intentionally created uncertainty and disruption for the Mountain West Conference. This is not a burdensome requirement for notice that is to be given to the conference. It's simple, man. Every athletic conference, every athletic department in America can write a check for $5,000 and mail a letter. They can do it in 30 minutes. It's not that difficult. So, the schools can't say, oh, we were getting to it. We were trying to get the money together. They could do it. And the Mountain West, when they saw the actions that were being taken by the other schools, namely joining another conference, announcing publicly that they were joining another conference, I'm talking about the departing 5 members here, starting to take that new conference to media, trying to get a media deal for their new conference, still actively recruiting members of the Mountain West Conference, most notably UNLV, who was, and rightly so, is seen as kind of the linchpin that's keeping the Mountain West together in its current form. The schools that left the conference were a part of the Pac-12, which was actively recruiting the Mountain West, inarguably their most important member. They were competing against them directly in the same media marketplace and were recruiting current members. These schools, starting in really October 2024, were acting not in the interests of the Mountain West. Now you may say, well, the Mountain West then probably was acting not in the interests of them. But these schools were the one that initiated this process, not the Mountain West. And the Mountain West acted reasonably in taking steps to manage its governance and financial uncertainty during this period, which included withholding distributions and limiting participation in decision-making in the conference. Think about it like this. If you run a company that has a top secret formula that you're trying to protect, and you hire somebody to come and work for your company for a 1-year contract, and 6 months through that contract, they say, hey, by the way, at the end of this, I'm starting another cola company, and we're going to start making moves now to start getting ready to compete against you. We're going to start seeking out the distributors that you're using and trying to lock them up for my new cola company. You, as a cola company, have the responsibility as a legal entity to protect your contractual and property rights. You cannot serve 2 masters in college sports. These members are either acting in the best interests of the future of the Pac-12, or they are acting in the best interest of the future of the Mountain West. Couple of counter arguments that are going to be there. The schools will argue, hey, we're just following the bylaws. May 31st, 2025. That's when we submitted our notice. And the bylaws clearly state that we're full members until then. However, the Mountain West Conference bylaws and this requirement for a formal notice, once you're acting outside the interests of the conference, once it's pretty clear you're joining another conference, you have a duty to give formal notice to the Mountain West. We're talking about I think it's 9 months. If I'm a little imprecise there, please correct me. We're talking about 9 months where something that would have taken these schools 15 minutes to do, something that all of these schools were able financially to do, they were not doing simply because they were trying to play both sides. Even if you want to say that there was a little bit of uncertainty around the Pac-12 in September and October, heck, even maybe November, in December, these schools had already brought a lawsuit against the Mountain West over exit fees. You're going to tell me that you can bring a lawsuit over exit fees. You can sue the Mountain West saying, hey, you're treating us badly, or you're doing this, but you can't send in your notice that you're going to leave, something that's going to take you 15 minutes to do? Give me a break. What this formal notice requirement does is it forces these schools, and this exact scenario is why this formal notice requirement was made. This protects the Mountain West, not the departing members. It forces them to pick a side, and if they don't, every contract, much like their own amended complaint, has a covenant of good faith and fair dealing. They were trying to play both sides. You cannot serve two masters. You are either acting for the interests of the Pac-12 or you are acting for the interests of the Mountain West. And we can see through their actions seeking a competing media deal, continuing to recruit active Mountain West members. We can see that they were trying to play both sides. Another argument is that the Mountain West should not have restricted participation until formal resignation. Why should these schools, over an 8 or 9 month period where they're clearly acting against the interests of the Mountain West, be allowed to participate in Mountain West decision making? Yes, the Mountain West made decisions that for the 2025 and 2026 seasons could have some impact on these schools. But you know what these schools did? They destroyed the conference. Don't talk to us about harms that you're suffering because, oh my gosh, Grand Canyon joined. And by the way, the Grand Canyon edition, as we'll get into later, was only made after these schools had, even by their own standards, given notice. It was made after the May 31st time when they actually gave notice, when they should have done it back in October or September. That's what I'm arguing here. But the Mountain West has a right as a corporate entity and as a group of schools to make decisions that are in its best interest. And these schools were no longer acting in their best interests. And any harm that they're suffering is so minimal, and the conference is willing to negotiate and compensate them for any incidental costs they may incur because of this addition of Grand Canyon, that it is just a pathetically weak argument to act like their rights have been somehow. It just seems like, hey, we want to control the new Pac-12 and we want to control the new Mountain West. And you ask yourself, if you're a judge, do you think that's fair? Do you think that a group of schools that are actively competing against the Mountain West should have rights to govern the Mountain West? Absolutely not. The Mountain West is protecting itself, and as a company that has member institutions, the Mountain West had a duty to take these members out of their active participation roles and restrict their rights, because based on their behavior, it was pretty dang clear that they were not going to be part of the Mountain West moving forward. Let alone them telling the world. Boise State literally flashed the Pac-12 logo on their stadium, and then they sued the Mountain West. You don't think it's clear what type of relationship they were in? You don't get to act like there was some level of uncertainty as to whether you were leaving the Mountain West or not. It was pretty dang clear. And you do not get to control two institutions and act at the detriment of other for the benefit of another. You don't get to do that. So in conclusion, the Mountain West was absolutely justified. And again, I implore you to read through my motion to dismiss and try and poke holes in it. I dare you. Please try and let me know what you think. The school's delay in following the resignation process created an unnecessary uncertainty for the Mountain West, justifying its actions. Even if you want to say the Mountain West wasn't perfect, maybe they should have waited until December or late November to kick them out of the board and to start withholding distributions. Even if you want to say that, what these schools did to the Mountain West and the level of uncertainty, they talk about uncertainty. The Pac-12 was still recruiting UNLV and still trying to pry schools out of the Mountain West basically until June. You want to talk about uncertainty? By enforcing its bylaws, the Mountain West acted to protect its governance and financial stability during a time when schools were acting contrary to the conference interests. The Mountain West actions were not only within its rights, but were a necessity to protect itself legally, financially, and contractually. And therefore, the Mountain West was justified. And these schools, this sham notice that they gave on May 31st that was clearly designed, that had nothing to do with whether they were deciding to whether these schools were actually deciding to leave the conference. That was decided months ago. How about when you brought a lawsuit versus the Mountain West over your exit? That you weren't clear enough then? The schools had a duty to give notice once they decided to leave the conference, and they didn't do that. And by not doing that, this formal process requirement protects the Mountain West and not these schools. They did not act with good faith and fair dealing in how they handled their exit. Point number 2 is that, and that was the longest point, we're going to be a little shorter for these. Exit fees are enforceable, guys. They're liquidated damages designed to cover the costs and losses associated with the school leaving a conference. Guess what? There's a ton of weird and random costs that happen when 5 of your top member institutions leave your conference. Liquidated damages clauses are standard in contracts, and while they are held to a higher standard, 3 times an annual distribution is an amount that has been upheld and followed in other conferences. The amount that the Mountain West is asking is not some exorbitant amount that hasn't been applied by other schools in other conferences. In fact, it is very similar. Your school just signed on and agreed to liquidate it to exit fees that are incredibly similar to the exit fees that exist in the Mountain West right now with their new contract with the Pac-12. You just said when you signed the grant of rights with the Pac-12, exit fees are great, we're down, we think that they're legal. You just said that. Boise State, when it signed its grant of rights with the Pac-12, said that they agreed that exit fees were enforceable. And now in this lawsuit, you just said, that's like saying, I think that it's probably a good idea not to drink and drive. You shouldn't do that. And then going and doing it. It's hypocritical. You know what I mean? You just, by your own actions in joining the new Pac-12, agreed that exit fees are enforceable. And they have been enforceable and upheld for 50 or 60 years in college sports. The exit fee is not a penalty. It is a reasonable pre-estimate of the damages that the Mountain West would incur from the departure. And the Mountain West was smart in how they worded the exit fees. They said 3 times the annual distribution. They didn't try and come up with some crazy number. They just said, hey, give us 3 times what we give out to you annually if you want to leave the conference. That is something that's standard across college sports. It's very similar to what you just signed up for in the new Pac-12. And, I'm sorry, you do not want to go to court trying to argue that exit fees are unenforceable, especially when the Mountain West in 2021 updated its own exit fees with the input and, with the decision-making power of these very schools that are trying to now say that they're not valid. Your own actions, past, present, and future, indicate that you know that these exit fees are enforceable. They're routinely upheld in contracts, particularly when they're a reasonable estimation of damages. And if you think that 3 times the annual distribution is not reasonable, that's the standard across college football. What is reasonable then? That's the way that conferences are doing this right now. The Mountain West exit fee is based on an average per member distribution and designed to cover the real costs of reorganization and losses for a departure. You know how much it's going to cost the Mountain West to try and replace all of these schools? They had to go out and recruit new schools. They had to redo scheduling. They had to redo a media deal. That is tens and tens and tens and tens of millions of dollars, and it is difficult to quantify. Then they try and argue that the exit fees are a double recovery. The Pac-12, when they're arguing about poaching penalties, they can make that argument that because the exit fees are in place, poaching penalties are not enforceable. It's penalizing the same conduct twice. It's reimbursing the same conduct twice. But in order for that argument to work, they actually have to have the Mountain West has actually had to have been reimbursed for those exit fees in the first place. The double recovery thing only works in terms of the case for the poaching penalties, not for the exit fees, because the exit fees are the traditional and agreed upon by these parties mechanism to reimburse the conference for leaving. I am sorry, being #built different up in Boise or being Aggies all the way does not mean that you do not have to follow the rules that you yourself helped create. If you want to create an 8-member conference that has no great or realistic expansion targets at the current point, that's going to have that's going to have scheduling difficulties because of its size. If you want to do that and create the new Pac-12 and create a really good solid G5 conference, no problem. That'll be $100 million, please. That's what you signed up for. The Mountain West used these legal tools to protect itself from this exact scenario. It foresaw this coming, and these tools are simply acting as they were designed. Exit fees are standard, guys. You're not gonna disprove exit fees. You're not gonna say that exit fees shouldn't be allowed. You know, it's just good luck with that, man. Good luck. They're standard across college sports. You yourself helped enforce them when San Diego State tried to leave the conference in 2023. You yourself sought to enforce these exit fees. So you're going to try and enforce them, and then when you do it, it's, you know, well, when San Diego State did it in 2023, you know, we didn't, you know, obviously we were going to collect those exit fees, but we're hashtag built different. We have a blue turf, so exit fees don't apply to us. But they applied to San Diego State in 2023, but now because we're us, exit fees don't apply to us. I'm sorry, they do. And I have no problem with these schools, and I get that I'm being snarky here. I have no problem with these schools trying to protect themselves legally, but this is not a winning case. The poaching fees totally might be a winning case here. And just because I think the Mountain West has the winning case here does not mean that I do not believe the Mountain West needs to come to the table and negotiate these exit fees and figure out a reasonable price that both parties can agree to. But you are not going to go to court and challenge exit fees. Good luck. That's like going to court and saying, you know, murder. Yeah, that's not the greatest. That's not the greatest example, actually. I'm just trying to think of a long-standing, legally held, enforceable contract provision. It's going to be enforced in this section. You're not going to go to the criminal court and say, yeah, well, murder doesn't really apply to us. No, murder's always been applied. It's always been a law, and this is contract law, and it's going to be upheld. The last point, I think this is probably the most important point, because even if, now, there's no way that I can't see any court in America that's going to strike down exit fees altogether. But even if you believe, so we're going to kind of throw that part out just for now. Even if you believe that Boise State, these party members, had their rights violated when the Mountain West locked them out of governance, these schools have suffered no harm. Even if the Mountain West did not act correctly and was not perfectly and, you know, legally perfect in how they handled this exit for all these schools, what harm have they suffered? The court will not allow this motion or this amendment, this complaint to go forward unless these schools can prove that there was harm done. So what harm was done? The partnering schools have failed to show one. They claim that the Mountain West withholding distributions is a harm. Guess what? Those distributions are being withheld to be paid towards your exit fees. The Mountain West is simply collecting and protecting its contractual obligations and duties and financial obligations and duties by withholding that money because they don't trust that you're going to pay the exit fees. They're only collecting money that you already are legally obligated to pay. The Mountain West Conference bylaws allowed withholding of distributions and other actions. Even if you think that you gave notice on May 31st, 2025, and the withholding should not have begun until then, you still cannot claim that you've suffered a harm because the Mountain West is not withholding money that you are legally obligated to. It is withholding money to pay off your exit fees. Any temporary limitations, such as voting rights, were directly tied to the school's failure to actually fulfill their contractual obligations to resign from the conference once it was clear that they were not going to be a part of the conference. So if your claim, and this is why they're pushing so much on the Grand Canyon thing, because they're, you know, it's a losing case to try and say that, you know, you're suffering harm because the Mountain West is collecting its exit fees. It's a losing case. So if your claim is that Grand Canyon is joining the league a year early, give me a big fat break. Grand Canyon is in Phoenix, Arizona. It's highly accessible. They've got solid programs. The schools have been promised, apparently, supposedly, and I'm sure the Mountain West will do this because there's no reason not to. The schools have been told that the Mountain West will help compensate any travel or incidental costs by the Grand Canyon, by Grand Canyon University joining the conference. So what are the harms that they'll suffer because Grand Canyon joins? Wow, they might have to reschedule a softball game, a travel cost. Oh my gosh. Is it some TV cost? No, Grand Canyon didn't play football. Are they changing the number of basketball games in conference that you're going to have to play? No. All you're doing, oh my gosh, you have to play a good basketball program. You might even get a quad one game out of it. Oh my gosh, what harm. You want to talk about harm? Talk about destroying a 25-year conference with all the leverage in the world over Washington State and Oregon State, just so that you can create two weaker conferences. And instead of having a joint conference that is stronger, united, and temporary until the early 2030s, you have created two weaker conferences. That's what you've done. You want to talk about harm? Think about all the harm it's caused the Mountain West and the Mountain West schools that got left behind by the departure of all of these schools. And by the way, I have no problem with these schools doing this. Like I don't blame Utah State for leaving the Mountain West Conference. I think UNLV should have left the Mountain West Conference. But it's undeniable that those actions were harming the Mountain West far more than having to reschedule a softball game because of Grand Canyon. Please cry me the biggest, fattest river through Tempe or through Boise. Like the harm that you're claiming that you've suffered here, that the conference has already said that it will reimburse you for. It does not matter if you think that the Mountain West acted unethically. If you can't allege an actual harm that you've suffered, because the Mountain West is just withholding money that will pay off your exit fees, money that you're already contractually obligated to pay. And Grand Canyon, cut me a break on the harm that it's causing you. You just don't like that you don't have control anymore. But guess what? You joined a new conference. You control that conference. Stop trying to control your old one. You gave up those rights when you left. And Grand Canyon, additionally, wasn't even officially added until after the May 31st deadline for formal exit. They didn't get added until July. So what's going on here? You didn't have a right to stop Grand Canyon from being joined in. And if your allegation is that Gloria Navarez made representations to you before the May 31st deadline that Grand Canyon would not be added, what proof do you have of that? Because when I read through the amended complaint, not a lot there. It's a heightened standard when you're alleging something like fraud, which is what the conference is doing. So, this point cannot be emphasized strongly enough. You suffered no harm. This money being withheld from you, yes, it's a burden, but it's a burden paying off a contractually obligated fee that you yourself created. Any claims for financial harm or loss of voting rights are either minimal or there's no harm attached to them. Therefore, in conclusion, the exit fee is a valid and enforceable liquidated damages provision as evidenced by the last 60 years of the way that college football realignment and college sports realignment has worked, and by your own actions in entering into a new set of bylaws that also have these exact same provisions. The schools haven't demonstrated a tangible harm resulting from the Mountain West Conference actions. I beg you, because in court, guys, I get that on Twitter, we can kind of have, pissing matches sometimes about this kind of thing, but in court, you got to actually show your work here. And, the schools didn't properly act in terms of how they handled the exit. They should have provided formal notice when they were obligated to provide formal notice, when they started acting against the best interests of the Mountain West Conference. So guys, that was a lot. I understand that it's a heated topic. I understand that you may not agree with me, and that's okay, guys. Like I can take the criticism. Lay it on me. Like, let me have it. Let me hear it. I do, again, believe that the Pac-12 has a strong case for poaching penalties. I do respect these schools trying to, before the 2031 kind of seismic event, trying to separate themselves or distinguish themselves in some way. But I could not be any less impressed by this complaint, by this amended complaint from these schools leaving. Again, I think the Pac-12 has got a good argument. These departing schools, this argument sucks. And it's all just a part of a stall tactic, in my opinion, to try and kind of force the Mountain West hand. The Mountain West isn't going to run out of money, guys. They're withholding your distributions. They're using that money to pay for these exit fees, to pay for these legal fees. I don't have any doubt that the Mountain West can keep this going until the very end. And I hope that the Mountain West does not cede ground on this exit fee case, because I think their case is really strong. So guys, let me know your thoughts. I want to know your opinions. I want to know where you think I'm off. I want you to read through my motion. I did my work is there. If you think that I'm backing this stuff up, like this isn't just, I'm not pulling this crap out of a hat. And I want to know your thoughts. I appreciate you guys checking out the video. I understand this was a little harsher, a little longer, but I wanted to make sure that I did my homework first. And I would appreciate you guys liking the channel, subscribing. I love all of these schools that are remaining in the new Mountain West, schools that are going to the new Pac-12. I love talking about all of these schools. I love the fan bases of all of these schools. I really do. And I think that this is a fun topic, and this is just kind of the crap that I live for. And I was representing the Mountain West in this case. So you have to understand that I came at this from an angle of being a representative of the Mountain West, a client which in the past and today I have vigorously done my best to defend. So there you go, guys. I appreciate you checking out the video. Have an awesome week. Thank you so much. Let me know your thoughts, and let's run.